Okay, welcome. We'll probably have some people join us as we go through, but I think we can kick off. Welcome, everyone. My name is Nick Caton. I am chairperson for the Alliance for Finance, if you don't know me already. We have got a just a short one today on resolving disputes in the workplace, and I'll explain a bit more as we go through about what we specifically mean about that. But thank you for joining us. Kevin is going to be looking after the chat, and he will be picking up any questions as we go through. We have a short time at the end. So if you have anything, then please just put it to me, and I'll do my best to answer it. Obviously, please respect any confidentiality in your organisations. Don't mention any specific person by name. But if you are, going through a case or whatever, and you have a specific question about the processes, then I'll do my best to cover it off. If you ask a really detailed question about discrimination law, probably not going to be able to answer that in the space that we've got, but I'll do my best. So I have a PowerPoint which I will be sharing with you. So hopefully I can do this. Yep. And we'll just be going through this. And what we are going to be discussing today in full is the right to be accompanied, what that means, and the benefits of using informal resolution, because a lot of the processes we'll be talking about today are what we call kind of formal, and the difference between those is important, and we'll get to that in a second. The role of the rep during the formal process, and for you to understand and identify what the formal processes that we'll be using are. So first of all, role of the rep in dispute resolution. So when I use the word dispute, I'm really saying anything that one of your members might come to you with. Okay, it's a question. It might be that they're in trouble. It might be that they've got problems. Whatever it is, we use that term dispute to kind of discuss anything which needs to be resolved. Okay. And they'll obviously come to the union representative if they're a member. And that union representative, as I'm sure you're all aware, is just a member who has been elected by the membership. I say elected, more often than not, it's just that's the person who is willing to do it, or some other people have said, oh, you'd be good at that, or whatever it might be. But the union has ratified the fact that you are a representative, and we want you to be kind of first point of call for our members. And their role is to represent, give advice, and in a way actually kind of see problems arising before they actually become problems, and fix them then as well. And the idea is to make things better, maintain a status quo, or make things less worse in situations where it's already obvious it's going to be not ideal for members. So when we are the procedures that we're going to be talking about today, the first one, informal resolution, not in itself a procedure, but incredibly important. We'll discuss why. And then we will discuss the formal processes, and they are disciplinary, capability, and grievance. So those are the three that we'll be discussing. So disciplinary, obviously, when an employee has done something that the employer does not like. Grievance, when the employer or another employee has done something which your member doesn't like. And capability we'll discuss in a bit more detail, but ultimately is disciplinary, but for specific reasons. So first of all, the right to be accompanied. Why I said it's important to differentiate between the informal part of any of these procedures and the formal part, i.e. that disciplinary meeting, that grievance meeting, that capability meeting, is because once those things happen, there is a legal right to be accompanied. Okay, it's not a nice to have, it's not a depending on the policy, it is a legal right under the Employment Rights Act, that an individual who's invited to a disciplinary or a grievance hearing has the legal right to be accompanied by a trade union representative or a colleague. Okay, so you might sometimes get the question, my mum's in HR, can she represent me? No. That is, it's a trade union representative or a colleague. And who has that right? Everyone has that right. Okay, so you might also come across people who might be, I don't know, contractors or agency staff or whatever in your organizations, who say, well, I can't be a member of your union because this is, my employment status, and therefore, I don't have the right to be accompanied. That's not true. Everyone has the right to be accompanied in these hearings. And it doesn't depend on union recognition. So for some of you, that might not matter to a certain degree because you're working in only one employer. But for me, for instance, I work for Community. We're a general union. We have members in various different places, and I may just as well be invited to a meeting in a shop in town as I am at Zurich Insurance or something like that. So it doesn't depend on whether an employer recognizes the person. The only difference there is that when an employer recognizes a union for the purposes of collective bargaining, they are obliged to give union representatives reasonable time off to attend such things. Whereas, if you have officers who work for the union, then part of their job, part of their paid role is to go to other places and represent people, even though they might not be represented. But obviously you will not get the time off to go represent someone at Burger King or something like that. When I've already discussed, so it has to be a grievance or a disciplinary hearing. It does not apply to investigation hearings. Okay, now your employer may allow it, and it may actually say in your policy that it is allowed. Most don't give that right. But if you have a good relationship with, say, the HR or the managers or something like that, and it's a particularly sensitive issue or one that may cause your member distress, or your member suffers from mental health issues or something, or they've been through a personal trauma, something like that, then you can ask the question. And the worst that can happen is it's turned down. But I think sometimes it is possible to ask and useful to be represented, even if it hasn't got to that formal stage as yet. So the individual also has to make a reasonable request. Now, what that means is that basically they have to choose a rep who is in a similar sort of situation. They can't choose a rep who, for instance, if they're in Southampton, who works in Edinburgh and is on holiday for the next 3 weeks. That may not be reasonable. So they'd have to make a reasonable request, and more often than not, the employer will ask that the companion is named to the hearing manager within a certain amount of time, or a certain amount of time before the hearing. So do just check the invite letter. And it's important to note that you also have a legal right to postpone the meeting should you not be available to represent your member. I'll say that again, should you not be available to represent your member. Now, I'll be honest with you, I have seen this being used by others, not myself, of course, as a delay tactic to the disciplinary and grievance hearing, but that's not what it should be used for. Okay, if a member doesn't feel that they have enough time to prepare, then that is a failure of the ACAS code, because the employer should be given reasonable time for the member to prepare. So you should use that route. This is if you are not available to attend the meeting. And it's important to note that you only get one postponement. If you can't attend the second one, or the member can't attend the second one, then the meeting may well go ahead without either of you there, or the member there, you can be there. But the second meeting, that postponed meeting, the employer has the right to go ahead whether or not you're there or not. So it is important that if you are postponing, that you pick a reasonable time, a reasonable place, a reasonable date that is suitable, that you are sure that you are going to be able to go to. The code says that what you should do, the law says that what you should do is write to the employer and say, unfortunately not able to make this, and then give a reasonable time and date, and the employer should then, if that is reasonable, should then just put it in. In practice, what you do is you call up the hearing manager. You say, listen, I can't make that, can we arrange for another date? And you speak with your member and you figure out some dates that are mutually convenient for all of you. Okay, so if I can move along. Yep. So again, another kind of hurdle you might come across because of the wording of the right to be accompanied is, I don't need to join a union. If I get in trouble, I can take a colleague with me, or even worse, can you represent me not as a union rep, but as a colleague? Now, and I say this to all my reps, it's not my place really to tell my reps whether or not they acting as a companion, as a colleague, sorry, that they can't accompany someone to a meeting, but I very much tell them that they can't accompany people to a meeting as a colleague, because for one, it does their reputation absolutely no good as a union rep. You're there representing your union, and therefore it's important that you do so. And if people think that they can get some kind of representation from you without being a member, then they won't join. But other than that, if someone wants to, thinks, oh, my mate Sam basically knows about this stuff, I'll just ask them as a colleague. Well, the fact is that Sam might know some stuff, but he hasn't necessarily had the training, doesn't necessarily have the experience, certainly doesn't have the backup of the rest of the union. If should things need to escalate, and really importantly as well, part of the union's insurance covers you personally should you give negligent advice. If acting outside of your capacity as a union rep, you give negligent advice which leads to someone's dismissal, for instance, then you could be personally liable. That person could sue you. So it's important that you recognise that as part of it only covers you as part of your duties as a union rep, and part of the obligation that you and the union have to make sure that you are covered by that insurance is that there is reasonable steps taken to make sure that you're competent. So things like training or monitoring and things like that. So make sure that you are going along to the training, that you are meeting as a branch, however you do it, then that's all part of making sure that you're all covered by that insurance should it be needed. You may also be able to draw upon legal advice from lawyers. I know in community, for instance, we have a panel of lawyers who deal with everything from employment issues through to personal injury, conveyancing, probate, family law stuff, and things like that. So, all of those things are there should it need to be escalated. And then obviously there are specialist teams who can do that. So when we talk about the procedures, they're really covered by these three main areas, and these are important in to the background really of why these processes are in place and what makes them fair and what makes them reasonable, etc. So the first one is the law, which is the fair reasons, and the main bit is the fair reasons for dismissal. So in employment law, there are certain reasons that an employer can give which are potentially fair reasons for dismissing someone. Whenever I do this and I pull out a board and I ask people to give me what the fair reasons for dismissal are, they always come out with the same sort of things like fraud or theft or violence and stuff like that. Those are all potentially fair reasons for dismissal, but those are not the reasons in law. The reasons in law are this: conduct. So that is something that you have done which the employer deems unacceptable. Okay, conduct. So that is theft, that is fraud, that is violence, that is drug abuse, and everything that comes out around things that you have done which may well go against the company's values, policies, or are just known to be wrong in that sense. The second is capability. So the capability is basically that you are unable to fulfill your contract. And the main two reasons that would be are your performance or your attendance. Okay, and we'll come on a bit more specifically about those two things shortly. But ultimately, there is, a expectation for every employee to be able to fulfill what it is that they're asked to do for the money that they're being given. And if because of performance or attendance they can't do that, then capability is a potentially fair reason for dismissal. The third one is redundancy. So redundancy basically means that the job does not exist anymore. Okay, and it's important there that we could do a whole thing on redundancy, but redundancy is the job doesn't exist. It's not about the person's moving on or whatever. It's the job has left the organization, and there's two main reasons for that. Either the company have come up with a new way of doing things, so they've reorganized, or a piece of technology has come in, which means that job is no longer necessary, or they can't afford it. Okay, they want to save money, either that they literally can't afford it, or they need to make redundancies in order to stay competitive in the market. So they will just remove chunks of jobs, or one or two jobs, whatever, because they feel that they can make savings. So that's redundancy, and I'm sure you'll all be aware of what then happens in terms of consultation, etc. Trying to remember them all now. The fourth one is potentially fair, but not necessary. It's not automatically fair, and that's retirement. I say potentially fair. You'll all be aware that retirement was default retirement age was gotten rid of a long time ago. But it is still possible for an employer to have a default retirement age, but it's just that they have to be able to justify why it's fair. I have yet to come across an actual example. I've read about a few, but I'm yet to come across an actual example in where any employer that I deal with has the gall to try and suggest that once you hit 65 or 66, you're suddenly not able to do your job. But there are some examples that have been tested out, and I think the a common one that I give as an example is air traffic controllers. And the reason being that the risk to life is so great that the slightest drop in cognitive function means that they are able to justify having quite a low, I think, default retirement age. But that's not through practice. I don't know that for sure, but I have read that that's one example of where they've tried to do it. The next one is breach of a statutory duty. So this is basically where it would be illegal to continue to employ this person. So common examples are that a person loses their right to work in the UK. So if they have a visa or some other right to some other document that gives them the right to work in the UK, and that is rescinded for whatever reason, then it would be illegal to continue to employ them, and then the employer is able to dismiss. Other common examples might be if a driver, for instance, loses his license, or if they were to put the drinking age up, and the age that you're allowed into pubs, then 18-year-olds potentially would be dismissed because of this legislation. And the final one, everyone's favourite, is some other substantial reason. Okay, so the important word there is substantial. I've come across this a couple of times. It is basically that the employer has a very, very good reason as to why they can't continue to employ this person. So the common one, which I think some of you may have come across, even if you didn't realize it, a few years ago, was when a lot of companies got rid of changed their pension offerings from a defined benefit scheme to a defined contribution scheme. Now, what will often have happened in that situation is people will have had contractual rights to a defined benefit pension scheme, and the employer was saying, well, we're moving this, so we want to change all of your contracts. And more often than not, they would have gone through consultation and said, anyone who doesn't sign up to the new scheme, we're going to dismiss you and then re-engage you on the new terms. And their substantial reason was that we can't afford to do this anymore. And the more and more companies that did that, the more and more airtight that argument became, because you couldn't have 15 companies who had moved to a defined contribution scheme and then one saying, well, if they're all doing it, then I can't survive without doing it. So therefore, that argument potentially for some other substantial reason dismissal probably would have been fair. This actually is what you will have read of in newspapers quite recently with things like P&O. This is fire and rehire. Some other substantial reason dismissals is fire and rehire, basically saying we can't afford to do this anymore, so we're going to fire you and hire you on new terms, which is not without its risks to the company. But again, it's it's for individuals then to refuse the new contract, say, no, I'm not coming back, dismiss me, and then try and take a claim for unfair dismissal, which, as we know, is potentially risky business in itself. But it has been done, and I've seen some of the substantial reason dismissals go to court and and be successful, and I've also seen them fail. So it's for you to assess, really. So those are the fair reasons for dismissal. So whenever you're going through a disciplinary, or capability, you have to have a look at, is the reason for dismissal, does it fit into one of those categories? And if it doesn't, then you've potentially got on your hand either a discrimination dismissal or dismissal because of union activity or something like that. So it's worth looking a bit deeper into that. Alongside that, you have the ACAS Code of Practice. Now, the ACAS Code of Practice basically dictates what is a fair process. Okay. Now, the ACAS Code of Practice is not law. However, it is mentioned in law. So when we talk about what a fair reason for dismissal, the piece of legislation about, what is a fair reason for dismissal is very short. But what it does, it then refers to, something like a court will then use the guidelines set out in the ACAS Code of Practice on disciplinary and grievance to decide whether or not the process was fair. And so the ACAS Code is not law as such, and it doesn't necessarily have to be followed. But what an employer has to do is treat that as a minimum, and if it's not following it, have a really, really good reason as to why they're not following it. Okay. The ACAS Code, as I'm sure you're all aware, it's available online. It's easy reading. It's not rocket science. And it just sets out, what an employer should follow in order to be able to justify that the process has led to its decision to dismiss has been fair, and therefore it leads to them being able to say that actually the reason they gave is fair because they followed a process and they made a decision that was reasonable in the circumstances. So you have that, and I mean, just a side note, if an employer or even an employee, if it's going through a grievance procedure, doesn't follow the ACAS Code of Practice, that could potentially impact any award that's given at tribunal should they be successful. Excuse me. What was used to be called, I think it was a Polkey adjustment. So basically, I think it's 25% up or down if an employer or an employee fails to follow the ACAS Code of Practice. So it is an important thing to be able to look at and make sure it's followed. So, for instance, things like making sure the individual uses the appeal procedure, and stuff like that. But that can be built upon, and company procedures are just as important. Making sure that they are compliant with the ACAS Code of Practice, but B, making sure that actually they go a bit further than that and are a bit more specific to your organisation. I always think that if you're in a unionised workplace, then you shouldn't be working to minimums. So you shouldn't be working on the basis that the ACAS code is what we use for grievance or disciplinaries. You should actually be building upon that. So do understand your company procedures, and some of them may be contractual, but a lot of them will probably have wording which was probably put in by a lawyer some time ago, which says these are not contractual and the employer reserves the right to change them or whatever. And therefore you get to a situation where just because they haven't followed the company process, that doesn't necessarily mean they're in breach of any contract. But here's the important point. If they haven't followed the company procedure, then you have to ask the question, why not? Why have they followed it for this person over here and not this person over here? And then you start looking at what is the differences. Is that a protected characteristic? Is this person a man, this person a woman? Is this person one race and this person another? And so, putting that argument to the company of you haven't followed your process, and here are some differences between this person here and this person over here where you did follow the process. Are you really willing to take that risk? Okay, so that's really a way to get round the fact that they may not be contractual, but they are still important. After all, they're the ones who wrote these processes, probably in conjunction with yourselves. So it's in there. They wanted to follow them in the first place, so they should. So informal resolution. Basically in our reps training, we spend a long time on this. We're not going to be able to do everything that I'd like to talk about informal resolution, but this is really the key part of your role. A lot of people will come to me on a regular basis saying they haven't done a disciplinary or haven't done a grievance in quite a while. Can they have some tips? And the reason why is they've been rep for years. They are able to resolve things before they get to that point. Now, not everything can be resolved informally. If there is a blatant act of violence, for instance, in the cafeteria excuse me, or whatever, then it may not be possible just to kind of have a chat and it all go away. But you have to ask the question: can this be resolved informally? And then, has there been an attempt at an informal resolution? And the second one can often be quite a difficult one, because you'll say to your member, well, has anyone chatted to you about this? And this applies to everything. So for instance, capability, someone's not performing to the standards, and you'll say, well, have they tried resolving this informally? And your member will go blind, swear blind that no, I didn't know this. But then you look a bit closer, and actually they've had 5 one-to-ones where they've been told, well, actually you're not hitting this target, you're not hitting this target. But the member didn't. When you use the terms informal resolution, they're thinking of almost a formal attempt at informal resolution. These sorts of one-to-ones, mid-year appraisals, whatever you might call them, those are potentially a form of informal resolution. So you need to be aware of that. Again, with conduct issues, or say something like lateness, has there been an attempt to resolve it informally? That doesn't necessarily have to be the manager going to them saying, oh, I noticed that there's a problem with absence, can we do something with your start times or whatever? But it could just be as simple as, just can you come into my office? Listen, you've been late a couple of times the last couple of weeks. Just try and keep an eye on that. That in itself could be an attempt at informal resolution. But even if that has happened, our job obviously is to then try and ensure that that more is done to try and resolve these informally. So if that chat has happened, it may be your next step is to actually ask the member, do you mind if I have a chat with the manager? Because obviously you always take direction for your member. And then speak to your manager and say, listen, is there something actually we can do without necessarily, it getting to a formal procedure and getting other people involved? Can we switch around start times? Have you thought about that? Is it possible? And they have less lunch and come out later if it's a problem that actually they can't get around. So have a think about those sorts of things. Ultimately, it maintains a good relationship. Guess what? Managers don't like grievances on their desk, and guess what? Our members don't like disciplinaries on their records either. So, and often, when you get a situation where a relationship is broken down between a member and a manager, you look back and you realize that at some point a formal procedure was instigated by one of the parties. So that attempt to maintain good relations, and apart from anything else, it's just human nature as well. If we can sort out problems with just talking to each other, then it builds upon the relationship rather than actually going completely the other way and potentially it breaking down. So it's a good idea to maintain that good relationship. It is also potentially more flexible. So the example I gave about lateness, not all, but in some organizations, you'll find that once it gets to a formal stage and say they have HR advisors or something like that, then given advice, you have a set way that this is going to go. It needs to be obviously reasonable, consistent. That's an important thing for HR to say. So therefore, they will say, well, in this situation, this is what happens. Whereas actually, if an individual and a manager can come up with a solution themselves, then that potentially is more flexible. You can potentially look outside the box in resolving certain things. So it's not always, but it's potentially more flexible. It's also an extra stage. We'll come on to the stages in a minute, very simply, but it is meeting, appeal, and then it's done. That's your standard process. So to have something before that means that you don't necessarily just have 2 bites of the cherry, but you have 3. And also, if you have that attempt at informal resolution, more often than not, you'll understand what the company's problem or the individual's problem is with that potential resolution. So you'll know, hang on, well, that's a sticking point, or that's a hard no on that one. So actually, is there another way in which we can approach this rather than going into the first grievance or disciplinary and just saying the same thing when actually that's going to go nowhere. It also avoids misunderstandings. I don't know if many of you remember, but a few years ago there was a very strict 3-step process which you had to go through in order to get to an employment tribunal. If you hadn't gone through the 3-step procedure, of raising a grievance, appealing, and etc., then you wouldn't be able to raise an employment tribunal claim. The reason that was brought in the first place is because the tribunals were finding that they were getting loads and loads of constructive dismissal or discrimination claims from individuals who had never actually asked them, told the manager that what they were doing was a problem. So this informal resolution issue is there to try and resolve issues, obviously, before they get formal, but from the legal point of view, also so that actually they don't end up at a tribunal and the manager sitting there going, I didn't know that this was a problem, so that's an important part of it. Often it is just a quiet chat, okay? Probably my most used phrase in this job over the last 18 years has been, have you spoken to your manager? Have you spoken to them about it? A lot of the time it is just, can we have a chat about this? Obviously, the individual should try where possible to have that chat themselves. But where it's not possible or it's not appropriate, or maybe you've got a better relationship as the rep, then you could do that, but always take instruction from your member. Don't assume and then just go away and have that chat, because apart from anything else, you might lose the trust of your member if they didn't want you to, but also you might be divulging personal or sensitive information without permission, which is a big no-no. It's important that you understand the issue and understanding it from both sides as well. It's important to understand actually what is the company's problem with this, so that ultimately how to circumnavigate that if that's even possible. And often that's checking the legal position as well. So if you've got a legal team, then use them. If not, then your own research, or if you've got more experienced reps, or just use what it is that you've got to check what the legal position is. Unfortunately, you'll often find, well, the employer can do this, or this is why it's reasonable, and that's a conversation that you might need to have. But I often find that actually having those conversations doesn't always just lead to the member getting in a strop about, oh well, it shouldn't be that way, but often it leads to the fact as, oh, okay, I'm disappointed, but at least I understand why. And sometimes that's actually all that is required for the individual to understand why there is an issue, why they're not able to move on a certain thing. And one that has come up quite recently actually is the 45-day consultation for redundancies. We had members saying, why do we have to wait that long? Why are we left in limbo? We all know what's going to happen. But obviously, once we explained actually that this is not something that the company have imposed, this is the law, then that satisfied them to a certain degree. And often that conversation will be with managers and or the HR department if that's appropriate. And a few years ago, the newfangled way to fix every employment relations issue was mediation. I'm not sure it's quite panned out in the way that everyone thought it was, but it's an important tool, and if used correctly, can be really invaluable, especially when relationships are at the point of cracking, if not have already got to that. So mediation is still something that you'll hear about a lot, especially in bullying, harassment type grievances, and ultimately it's about two people sitting down and having a conversation to try and resolve their differences without anyone saying, well, you're right and you're wrong. It's not about that. It's about, okay, how do we get over this? How can we work together going forward? So in the formal process, these are actually, again, stated in law. So it's not just what we advise or anything. These are the do's and don'ts as given to you by the right to be accompanied. So you are able to present the member's case and sum up the case. You are not able to answer any questions that are addressed directly to the member. So you can't jump in and say, well, this is what they think or they mean or anything like that. But you can ask questions, and that is often a way around it. Did you mean this, for instance? Or if you feel someone is not got the right end of the stick or has gone off in a tangent, then obviously asking questions to bring them back to it or to explain, or just infer what it is actually that you want them to say. It's a useful tool to use. You're not able to address the hearing without permission from the member, so always before the hearing get permission as to what it is that they want your role to be. Sometimes it is just for moral support, and that's fine, but obviously if you say something in a meeting and your member turns to you and says, I don't want you to speak, that's not a great look. So yeah, just make sure that you do get that permission, or ask actually what it is that they want your role to be. And you are able to respond on the member's behalf to views expressed in the meeting. So very specific wording there. So it is, you can say, well, in my opinion, from outside looking in, this is how I see the situation, or you can give clarity to the member, which is often something which is important because they, may have a million things going through their head, or be very anxious about it, etc. And unfortunately, you can't prevent the employer from explaining the case or contributing, or indeed the member. But I think it's a fairly common practice in the union world that if the member starts saying something that they shouldn't, that you give them a swift kick under the table. It's more difficult in teams, unfortunately, but there you go. So very simply, in a disciplinary hearing, you have these 4 main stages. So you have some kind of fact-finding or investigation meeting, or an interview. You might have witness statements, for instance, and those sorts of things. And as I said before, that can take many different ways. You can have kind of a specific team set up and meetings and getting witness statements, and then they have a pack of evidence which then looks at whether or not there is a case to be heard in under the disciplinary policy, or it might be I saw you do that. That potentially can be what it is, or facts and figures from workflow or something like that. There doesn't necessarily have to be interviews with members or colleagues or stuff like that. So when you are looking into whether or not there's been a fair process, do keep your mind open about what that final investigation or that informal stage, as it were, looks like. Then importantly, there needs to be a written invitation to a hearing, and that written invitation should state when the hearing is, and it should be at a reasonable time, reasonable place, and without unreasonable delay, and it should then state what the allegations are. Okay, and that's important because if it's not in that letter, you and the member have the right to say that's not what we're here to discuss. Can we come back to the facts of the meeting? So whenever you get that invitation, do check what it says. I think more recently, what I've noticed is those allegations are quite generic, so they encompass potentially quite a lot of things, and they may, well, especially in dismissal cases, I often find that they're just copied and pasted out of the disciplinary policy as to what constitutes misconduct. So have a look for that, and by all means ask for further clarity if it's not clear what the allegations are. And also you should, and this goes for both disciplinary capability and grievances, you should receive evidence before the hearing, or you should submit evidence before the hearing so that everyone's got the chance to prepare, unless it's not appropriate. So for instance, confidential information, CCTV in some circumstances might be appropriate, in some circumstances might not. So just look out for that. Then there should be a meeting. So there should be the hearing manager, who might be HR. They might be the hearing manager, or they might be there to support the hearing manager. And there should be a note taker, and that's not you, by the way. You can take your own notes, but they're not for the purposes of the hearing manager. They're your own notes, and obviously yourself and the member. And then you should receive an outcome to that following that hearing. That could be immediately, or it could be in a few days, or whatever. But it should again be within a reasonable time frame. What is reasonable? But it's difficult to say. Some employers actually like to say we'll write to you within 5 days, but often it's just what is reasonable. And there have been times I've seen where that's going on for weeks, maybe even months. But word of warning for any employers out there that there are cases of the employer not responding within a reasonable time frame, and then an individual leaving and claiming constructive dismissal. So that is important that they are as quick as possible in getting back. And then there should be the right to appeal. So often it will say within 5 working days of receipt of the outcome, then you have the right to appeal, and you should write to blah blah blah. Just a point on an appeal. Just saying I don't like the outcome won't get it overturned. Okay, well, I mean, unless you strike lucky and get the most understanding manager in the world or something like that, but it needs to be specific as to why the decision was not reasonable. Okay, so maybe it was too harsh, maybe evidence wasn't taken into account, maybe it's not consistent, something like that. You need to look at the outcome and say that bit isn't reasonable, and therefore that's the right to appeal. And that might include looking at the process that was followed to get to that decision. So things you should do before the meeting: you need to gather as much facts and information as possible. So meet with the member, for instance, and ask as many questions, open questions, closed questions, making sure you're getting as much information as possible. Explain the procedure as best you can to the individual. Many of the people that you'll be dealing with will never have gone through this before, so it might seem obvious to you, but it may not be to them. So explain what's going to happen, and explain timescales, but also explain that sometimes reasonable is the word that we use in employment law, because what's reasonable in one circumstance might not be another. Encourage honesty. Lying to a senior manager in a formal setting may well constitute gross misconduct, so just be aware of that, and honesty with yourself as well. I like to tell members, it's not me you're trying to convince. I need to know this stuff so that I can best provide support to you. Okay, finding out something in the meeting that you thought was not true, or the other way around, is never a good sign. And never advise resignation. Okay, as much as you might know that this person is going to get sacked, if you advise a member to resign, then you are shifting the risk of sacking that person from the employer to yourself personally. And probably you will have been told to never advise resignation, so I don't think you'd be covered by insurance. So just bear that in mind. You can say to the individual, one of your options may be, would you like us to have a conversation about that? If you do that, I would advise get that in writing from the individual, that they have asked you to have a conversation about whether or not the company would accept a resignation. And in the investigation, you can provide support and you can monitor the investigation, assess the case, and carry out the notes. But obviously, remember that you are not able to necessarily represent in any meetings, so just keep an eye on it, and encourage your members wherever you can to get in touch with you as early as possible. What I hate is there's a disciplinary in 2 days, can you attend? And I know nothing about it. I'd like to be able to do a bit more prep than that. In the meeting, some obvious things here: speak clearly, speak politely. If you are getting too heated or it's too emotional, or you're too close to it, I would consider whether or not you're the best person for that. You might be the only person. That might be what there's no choice with that. But just make sure that you are able to be clear, polite about the situation, and take out any emotion. Set it out concisely. The longer these meetings go on, the less the company may see the important parts. It might be watered down. So do set it out as concisely as you can. Be assertive, of course, and confident. Be respectful, though. Listen. Stick to the issues wherever possible. Make sure the member sticks to the issues. Do ask questions and try and get involved as soon as possible as well, because you can get into a situation where an individual and a manager, they've got this issue, they start talking about it, and then they are going on and on and on, and it's been an hour and a half, and you've just sat there, and you're a bit lost, and that's really difficult to then try and get into the meeting. So early on, whether it's through the introduction stage, whether it's through you setting out the case, saying this is what we're here to discuss, do try and get involved. Use adjournments. You are able to adjourn the meeting should you wish. That's often either to calm yourself down, calm the member down, calm the manager down. Those are important points. But it also might be because you've been going on for 2 hours and the member's exhausted. If the member also suffers from things like anxiety, depression, you might just want to take regular breaks anyway. Or it might be that new information has come to light. Might be that your members just said something ridiculous and you need to take them out and have a conversation. It might be that you need to phone someone to ask for some legal advice. So there's many reasons why you might take an adjournment. So yourself, the manager, the member, you're all able to take adjournment. So do so if necessary. And remain calm, as I said. And at the end of the meeting, I always like to summarize the points, the main points that the employer should take away from the meeting. So capability, as we've said, this is ultimately to look at performance or attendance, but it is a disciplinary. Now, and there is an ACAS code on capability, and often your capability processes, if you have one, will specifically say stages instead of warnings, whereas a disciplinary will say first written warning, final written warning, dismissal. But capability has stage 1, stage 2, dismissal. It's the same thing, okay? It's just called something different because ACAS at some point felt that it was not appropriate to call performance and attendance issues a disciplinary matter, but it is, okay? So you might not have a separate process, but it can result in dismissal, so therefore it is a disciplinary. And a disciplinary hearing, they often say, again, this should have timescales and targets and things like that. Disciplinary has that too. You have a first written warning, it'll stay on your file for 6 months, don't do it again. That's the same as someone saying you're not performing, we need to see improvement in 6 months, and these are the improvements we want to see. It's the same thing, so it's just called something slightly different. But there are specific things that you need to look at. So where it's related to performance, you need to have a look at, does the individual actually know what it is that they should be doing? Is there clear instructions? Is there any warnings that have happened before, informally or even formally? Have they been given an opportunity to improve, or this just landed straight on their desk? What training and support is available? And are there any other issues outside of work? Now, that might not always seem relevant, but I always find it's much better to be able to say, yes, this may be happening, however, this is something which is affecting me, rather than saying, well, I don't know why I'm not able to perform, okay? If it's absence related, you've also got some specific things to look for. Is there a medical condition involved and has it been resolved? So, if someone has had, for instance, COVID-19, let's say, and then, they've been off for a certain amount of time, but they've recovered, then the question has to be, is there any point from the employer to saying that we're going to be giving you a stage 1 warning? Has there been any medical investigation, especially if this is a long-term illness, which I will get to in a second? What support has been given? Is there alternative employment potential? And if it is a disability, so if it's an ongoing condition which is likely to last for 12 months and has an impact on an individual's ability to perform day-to-day activities, then it's likely to be covered by the Equality Act. And therefore, there is an obligation for the company to provide reasonable adjustments. So that might be, it might be things that you see all the time. So ramps to get into buildings, for instance, that is a reasonable adjustment. But more subtle things might be regular breaks, or moving someone around the office if, for instance, they suffer from headaches because of air conditioning. Things like this. It's you need to really kind of have a look. And often what you need there is an occupational health report to give you that specialist advice. So do look out for that, because that could be a form of disability discrimination. Okay. The Bradford factor, I'll just touch on this. You might not use this, but this basically is a formula that some people use, some employers use to figure out when a meeting is triggered under capability for absence. And the formula there is S squared times D, where S is the number of separate absences, D is the total number of days. And what that basically means is if you look at, if you work that out, it means that employers often will consider instances of absences, so 5 one-day absences, for instance, as worse than 1 5-day absence. And so, basically, if you have someone who has Friday and Monday syndrome, they're never in, and that happens a few times in a month, then their Bradford score is likely to be huge. Whereas if someone has a week off, it's probably not going to trigger it. So that might not be used, but do find out what the trigger points are. I've seen many. 3 instances in 7 days is one that I've seen, or 3 instances within 6 months, or 4 within 12 months, or 2 instances and 10 days. So these might not be in policies, but it's likely that your managers or HR have some sort of trigger. So try and find out what that is. Grievances, again, there should be an attempt at a resolution informally, and then you need to have a written details of what the grievance is, what the problem is, and importantly, how can the company resolve it? Often overlooked. You'll get 6 pages of a grievance and no indication of what the individual actually wants. So do make sure that that's in there. Then you should have a meeting, and again, the right to appeal, and all the things that we said before about reasonableness and etc. Exist there too. Grievance. So if a grievance is raised when a disciplinary is live, this is often when it happened, then I would seek advice from whoever it is in your organisation that you can get advice from. It shouldn't be used as a delay tactic. So if you think someone's going to get sacked, for instance, and you raise a grievance to try and delay that disciplinary, raising grievances without any need to, or without reason to, could potentially be seen as a form of harassment. So you need to be careful about that, and it shouldn't be used in that way. But if there is a genuine reason for this grievance, so for instance, I believe that the employer is bullying me, and this is another example of that, then the employer should hear the grievance first, unless it's completely not related. And very simply, the reason for that is a disciplinary can result in dismissal, and also the grievance might be valid. So do make sure that you are hearing the grievance first, or that the grievance is heard first. But they can happen at the same time as well. So you can have a meeting which counts as both, basically. So just take a bit of care before advising on that, and as I said, seek advice if you can. And also, witnesses, either party can call relevant witnesses as long as they give advance notice. But there are some problems. The main problem I find is that witnesses will tell you that yeah, of course, I'll back up what is said. But then actually, when put under the spotlight, they don't say exactly what you want them to say, or they'll actually try and justify it because they're being asked questions by a senior manager about potentially another senior manager or whatever it might be. So just be aware of that. Also, some people might not want to put their head above the parapet, as people say, and genuinely might actually be treated differently if they do it. So there are laws around that, but that doesn't stop it from happening, unfortunately. So that's about it. So just a quick summary. Do seek advice wherever. If you've got a branch structure, make sure you're using it. We always kind of give our reps a very simple, it's not rocket science, but problem, information, plan approach. You can Google it, and that just enables you to break down an issue and come up with a solution best you can. See what resources are in your organizations and use them, and do keep learning about this sort of stuff. You can never, I'm finding out things all the time about and considering what mistakes I've made 15 years ago or something. So do review any your own approach and as we go, especially at the moment when a lot of these things are happening online, and I think we're all still learning how to deal with that. So that was me. Thank you very much, everyone. I will. I've got a few minutes now for any questions on any of that. Just to say though, I will be putting this online on our website, Alliance for the number 4 finance.org, with the slides as well. So if you want to download those from our website, they should be up probably tomorrow. So please let us know. Thank you, Kevin, for your work in the chat. As you say, there is a mediation webinar on our website as well. In fact, pretty much everything we've done since the lockdown period is on our website. I'll say that again, allianceforfinance.org. I'll just wait a few minutes, see if anyone has any questions, which you can put in the chat. Otherwise, we'll call it there. Okay. Tanbir, do you want me to do you want to ask your question live, as it were? If you just click unmute. No, I can read it anyway. So the ACAS position on what's considered reasonable facilities paid time off for rep duties. Unfortunately, there is no answer to that, Tanbir. The answer is reasonable, and reasonable depends on the situation. So you really need to be looking at what your need for is, and what is going on at the time. So what is reasonable, for instance, if an organization is shutting down a branch of 500 people, is very different to if it's just business as usual. So the ACAS position is that an employer should give reasonable time off, and that's about as far as it kind of goes on that. So my advice on that is to discuss, on a regular basis with the employer about whether or not you're getting enough time off, and ultimately as well, to have the relationships that mean that the employer doesn't feel like it is that you are taking the mick with this sort of thing. I think when an employer sees actually this person is adding value, and they're using their time effectively, then it's not a problem. It's only suddenly when you find that reps are having 3-hour meetings every Thursday and nothing's coming of them, that I find that it's potentially an issue. So yeah, and I'm sorry I can't really give you much more than that, but it is all down to reasonableness. It's a word that we use a lot in this game. Kevin's given a little bit more in there. We have had facilities agreements which have specified the time. So I think it was 5% for reps and 10% for senior reps. But to be honest, I didn't really like it because it was very prescriptive, and when the employer was making large-scale redundancies, it went out the window anyway. Just quickly, the ACAS Code of Practice is obviously online. Just if you Google ACAS COP1, that should come up with a disciplinary grievance one, I believe, and they're all there. It's always good to understand what they say, but also what your own policies say, and being fully aware of that when you're going through disciplinaries and grievances, kind of threatening, if you like, that the employer may not be meeting its obligations with regards to the ACAS Code of Practice is often quite a big thing for them to say, for you to say. So do make sure that at all times you're using that or their own policies to make sure that they're being fair when they're going through their processes. But if that's all from everyone, I just want to say thank you for attending. I hope it's been useful. If anyone wants to drop us a line, then you can go on the website, click the contact, or you can email me directly, info@alliance4finance.org, and hope to see you all at the next event. Bye bye.